All right, folks, welcome back to the Land Fixer podcast. I am your host, Logan Swanson, and today we are talking land with the anonymous land lawyer, famous all over Twitter for his hot takes in the legal space as it relates to land. Um, Land lawyer, would you like to introduce yourself and tell us a little bit about not who you are, but what you do?
Yeah. So you can find me on Twitter at landlawyer Brian. Um, we solve tough title issues when it comes to land. We also do simple flips, minor subdivides, and other creative land deals.
Awesome. Well, I brought you on today, so I put together a little laundry list of questions and topics that I think you would be more than able to answer. So I think we'll just dive right into them. So the reason I think it's really important to have someone educating us in this space as it relates to land is because most of these educators, we'll call them, or gurus around the land investing space, um, really shortchange how important it is to have your ducks in a row, all the way from starting an LLC to the various liabilities you're holding every time you buy a property. Um, and especially as it relates to partnering, moving money around, all that sort of stuff gets real wacky and complicated. And you kind of need somebody in your corner to help address those issues. My relationships with attorneys to date has really been a lot more of me trying to educate the attorney and bring them up to speed because they don't know much about our industry for the most part. Um, so what you're doing, I think, is very valuable. And I have a few questions put together here that I want to start with. Um, First, there's been a bit of a shakeup in the real estate market as it relates to broker commissions, right? There was this big settlement wherein well, I guess maybe I'll let you relate the exact details, but effectively, there's a huge switch to how commissions are being structured and paid out in real estate transactions. So maybe you could tell us a little bit about that.
Sure. My understanding is that there's now, as a result of this settlement, not going to be required or pseudo required um, buy side realtor commissions. So the entire ecosystem will be somewhat more negotiable. I think it's going to have a far greater impact as it relates to single family residential properties. In terms of land, it could have some impact, but I think that it will be to a far less extent. And I'll just say this, we work with brokers when we're buying properties. You know, we find the market, we find the deal off market, but we'll present it to our brokers in that area. And after we've underwritten it, we'll get their opinion. And for that, you know, I want to compensate them on the sell side, make sure that they're happy with the arrangement as well. Our best brokers, we pay them 8% on the sell side, which is above market rate for the area where they work. But that's because they do an excellent job for us, and I'm happy to pay that. So I'm still going to pay 6%. I'm not going to, in our business, we're not going to try to, you know, sell with lower commissions. We're going to keep things like they are. So in my business, I don't see it had this settlement having that much of an impact. And I would be surprised if, there's a significant impact when it comes to selling land. And a part of the
Yeah, that's
reason
kind
why
of
that is like it's harder to sell land as a general rule than it is to sell a house. There's just more that goes into it. That's why you often see even in places where the market rate is a 6% commission, especially when it comes to smaller properties to make the juice worth the squeeze for the realtor, they're still requesting 10%. I really
mhm.
don't see that changing.
Yeah, and I'm kind of right there with you. I just had a couple calls this morning with some of our partners where we were discussing this issue, and yeah, I don't really see a good reason to maybe shortchange your agents on the sell side. Like you want them motivated to move your property, right? Where my concern is usually you would say take that 8%, and if there's a buyer agent that represents the buyer, well, they're incentivized because typically half of that seller's, the seller's commission is going to go to the buyer's agent. So you could raise your commission that you're paying to the broker and incentivize the buyer's agents to direct traffic to your listing. Um, and now that that's kind of swept away, I feel as if there has to be some sort of mechanism that comes in to replace it, whether it's sellers themselves saying, okay, we'll pay say a 6% seller's commission. And I don't know if there's a way to incentivize a buyer's agent now, whether it's like a fixed rate bonus to a buyer's agent or whatever it might be. I'm not really sure, but there ought to be something that you can use as a carrot to draw in those buyer's agents. But I guess, I mean, the whole point of the settlement was that in and of itself is an unfair practice, right? Because then you're incentivizing a buyer's agent to bring people to your property as opposed to maybe the best property for the buyer, right? What are your thoughts on that?
I mean, I think it's gonna that carrot is kind of determined still by the seller's agent. Like the brokers that I'm telling you about, like the commission we pay them is 8%, but
Mm-hmm.
they offer a 3% commission to the buyer's agent if they bring the property, they bring the buyer there. I mean, I just as a whole, I don't think it's going to be all that different. Maybe there will be some buyer's agents that start, working on a fee basis, but
Mm-hmm.
I think there's still going to be a lot of brokers that are sell side brokers that are still just going to say, 3% commission or 2% commission to somebody that brings a buyer because it's still adding value. It really is. And I think that the whole thing is overblown, especially when it comes to land.
Yeah, and see and I guess maybe I don't fully understand it. I've read a few articles over it, but my understanding is that practice itself is no longer legal, where the seller agent is sharing commission. Is that not the case?
Basically, it's all still negotiable.
I see.
So yeah, I mean it's not illegal, but basically there was a um they put it in the realm of essentially price fixing, that there was
Hmm.
this implicit agreement between buyers and sellers, agents, that you know the commission is going to be 6% and the buyer's agent will get half, but nobody's interfering with the right of private parties to contract with one another. And if that's the terms that everybody agrees upon, then that's fine.
Okay. Well, awesome. That's elucidating because I was like, I don't know how this is going to all shake out. My gut instinct tells me that it's going to, like most things that happen in this country, it's going to um, maybe empower the bigger firms and distress the smaller firms. Maybe the bigger firms are going to just say, okay, well, we're going to start slashing our prices or set fixed rates for transactions or whatever else. And then, the mom and pop shops where it's, a broker and two agents or something like that, that really can't operate without a higher commission rate are going to drop out or something along those lines. That's kind of what I feel like is going to happen. But I agree. I don't think it's going to be a huge shakeup in our industry, at least not in the short term. But what I believe we might see is, and I think this is kind of what Wall Street's telling us in general, is there will be a reduction in cost for both buyer and seller moving forward. That standard of 3% is just going to be, or 6% or whatever, is just going to be degraded as more people are willing to manage these transactions on a lower rate.
I think that's probably right. And I think that there's going to be less, weekend realtors, the person who just does this as a side gig. I think there's going to
Mm-hmm.
be a rise of more professional buyers agents who at scale handle this on a fee basis.
Mm-hmm.
Um, I think that the people who are getting the listings, they are going to be the people who hold the chips and can, demand what they can control what happens uh, more than more than anybody else. But ultimately, I really don't think it's going to make a difference in the sales price of a property because even if you're paying less in commission, if I'm selling a property and there's comps surrounding me at a certain level that are even from pre-settlement time, I'm gonna list my property in line with those
Hmm.
comps and then
Right.
still go up. So everybody that's talking about significant savings to buyers, well, the savings to buyers then would come at the cost to the seller, and the seller holds the chips. So why is he going to do that? He's not.
Hmm. Right. Well, perfect. Well, thanks for illuminating that for us. We do have a couple other questions I want to make sure we get to. This is a really big topic, not only for people in our space that are buying and selling land professionally, but also just Joe Schmo consumer who's maybe making their first land purchase, maybe building a dream home someday, or a recreational property, or what have you. But one of the big topics is mineral rights, right? So there's this whole separate world that exists outside of deeded land rights. And this is a big topic here in Texas, obviously, because there's a lot of oil and gas that's being mined or harvested. So there's big paydays for people that hold mineral rights that maybe someday there's drilling under the property, whatever. But it's not uncommon for the landowner to not own the mineral rights. There's a whole separate market where these things are bought and sold, and even as far as I understand, there's like a whole separate software system set up in order to even maintain all that data. So it's a big question or concern when people are buying a piece of land and maybe the mineral rights have already been separated. Do you have some useful information over that?
Yeah, I mean, I think it's totally state dependent. I know like states like Arizona and Texas, where the mineral rights were separated from the land a long, long time ago. Um, it's totally normal for people to just buy and sell the dirt and not the mineral rights by itself. In
Hmm.
other areas, I think, separating the mineral rights from the land, during the transaction, that could totally gunk up your transaction. So we never do it. There's some areas in Georgia where there's a mineral called kaolin. It's like a type of clay that goes into many different uh, many different products. I mean, everything from
Hmm.
like could be like lipstick to China. It's
Oh,
used in a
wow.
ridiculous number of things, and it's kind of like in the middle Georgia area. But yeah, I mean, in that area, like if you are separating the mineral rights from the land, I would say you're probably devaluing the land to a significant degree. So we've never done that. The big question, though, in terms of buying a property that um, has had the mineral rights separated, especially if it's you're going to build on it, it's your dream house, whatever, is are the minerals actually there? Because yeah, somebody can own the mineral rights, but you don't want them to come along and drill on your front doorstep or
Hmm.
create a pit in your backyard. So as long as you're fairly confident that the mineral rights aren't there or they're not there to the extent that they're actually going to turn your property into a mining operation, I think it's probably fine to buy properties that have had the mineral rights separated. And we've done that a ton. I mean, almost every property that we've bought in rural Arizona has had the mineral rights separated. And I know you're in Texas, and
Yeah.
it's completely common because people knew way back in the day that there was oil there. I'm not sure what
Hmm.
they were looking for in Arizona. Maybe they were hoping there was oil, but Texas, it's like par for the course. And I've even had sellers in Arizona that had their mineral rights say that, you know, hey, we're going to keep the mineral rights. And as
Yeah.
long as I'm confident that, it's not going to cause an issue, it's not going to cause an issue with me.
Right. So kind of digging a little further, and I'm sure this is state specific, and I don't know, maybe even more regional than that, but um, say you owned a property with a house on, like, I have a small lot here. It's a quarter acre lot that my house is on, and I don't own the mineral rights. So feasibly, if somebody wanted to come, I mean, I guess maybe mine's a bad example because there's a subdivision, and I'm sure they wouldn't allow someone to come just start pumping oil out of my backyard or something. But say feasibly you did have a property with a home on it. I mean, could a mineral like an oil company literally just come in and set up shop in your backyard? Or is it usually a longer process than that? Would there be compensation in place? Like, how would something like that really play out if it did happen?
I'm no expert in mineral rights, but yes, I believe that they would be able to come in and set up shop there and exploit the minerals. Um, I'm not aware of any compensation that they would be required to give you to do that, especially for something like oil that's pumped from underneath the ground. Maybe they might have to acquire, some the land rights in one of those areas to put to put a oil well, a drill and stuff on top of the ground to then access the minerals underneath. The scary situation would be like, say, in Georgia, where you have those kaolin mines. It's sort of like an open pit mine.
Hmm.
If they're able to, they have the right to exploit those minerals. You know, and again, I'm no expert on mineral rights, but I believe that they would be able to move your house. And say like, we're gonna go get that kaolin. The
Hmm.
comforting factor there, at least, is that it in large to a large extent, it seems like they're not making new mines there because they found kaolin mines elsewhere in the world that are cheaper to exploit.
Hmm. Yeah. So buyer beware on all that. And in fact, in it's so nebulous and kind of hard to track down ownership of some of these mineral rights, especially if it's like West Texas. Like there's certain areas where this stuff is just kind of traded constantly and bundled and just way outside of my realm. Um, but we have it even written into our deed when we buy properties. We don't even research if it's owned or, I mean, it's hard to track down. So we'll just say if the owner has the mineral rights as well, then we get them. If not, whatever. It's like kind of broad verbiage in our deeds. It's like we get them if they're there. I don't know. Um, okay, next question. So here's a really common question that I think is probably more dealt with in our industry, but I'm sure people that are out there buying land are going to stumble into these sort of opportunities. But there's a lot of property in this country that has no legal access. So I was wondering if you could review what a landlocked property is, and is it a no go? Like, should you never buy a property that's landlocked? What's your thoughts on that?
Yeah, so a landlocked property is a property without legal access. So typically, when we buy property, we want to have both legal and physical access. That means I have the right to get from a public right of way, like a road, and without trespassing on somebody else's property, step foot on my property. So that's legal access. That can be that your property touches a road, or it could be that you have a legal easement to cross over somebody else's property to get to yours. And then, of course, like I said, you want physical access to where there's nothing physically blocking you from being able to step on to onto your property from that public right of way. Um, being a property being landlocked in terms of legal access, like, it seriously devalues the property. But that's not to say that you should never buy it, because a lot of times you can unlock value from a property by going and establishing legal access. You could buy, reach out to the property owner between your property and the right of way, and you could buy that property. Or if they don't want to sell, you can establish an easement to get over their property. And you can do that. It all comes to negotiation with with that person who's going to sell you either their property or an easement over their property.
Mm,
Another thing that you can do in some jurisdictions, there are jurisdictions out there, and this is all, varies by state, but in some places there's a statutory right, meaning that the General Assembly, the legislature of that state has said you have a legal right to be able to access your property, and you're able to, if they won't grant you an easement, you're able to sue them and obtain a legal easement through that process. Why does that exist? As a general rule, states don't want land to just go completely unused or to be unusable because you can't access it,
mm-hmm.
right? That's also, the fundamental underpinning of adverse possession, where, if
Yep.
you fence off somebody else's property for the statutory period in whatever state it is, it could be 21 years, like it is in Georgia, or 7 years under color of title. And if you have open, notorious, and exclusive possession for that time, then you can have a quiet title to get a court to say, oh, you own this land. Similarly, you can go request an easement from the court, but let me tell you why it's better to negotiate an easement rather than go and ask a court for an easement. Now, in Georgia, if you go ask the court for an easement, they say, yes, you have the ability to request a private right of way for access to your property. But what that doesn't include is the ability to bring utilities to the property.
Mm,
So, yeah, you can go, drive your car to the property. You can walk to your property. Yeah, that's great. You can use it for hunting. You can hang out there. You can put a house with solar on it, whatever. But what you can't do is pull a power line down the road. So the best option and how to not piss off your neighbor is just call them and say, hey, I'm buying this property. The title reports come back and it's saying, I'm landlocked. Will you
mm-hmm.
help me out with an easement? And I'm not one to ask for something for nothing. So I'd like to pay you for that. And the times that we've dealt with this, almost always they're happy to work with you, especially if you can put the easement in a place that's not particularly burdensome to them. If it's going right, if the easement would go right next to their house and then you're constantly going to be driving back and forth, they might say no, go kick rocks. But if you can establish a line, you know on the edge of their property, they're probably way more likely to do it. We
Mm-hmm.
have a deal that we've been working for months. It has a tough title issue. We had to go through a probate in Washington State, even though this property is 60 acres in Georgia. It at one time was it at one time had road frontage like back in the 70s, and sometime between the 70s and the 90s, county's telling us that they abandoned this county road. Now, when a county road is abandoned, at least in Georgia, the property owner of the, now quote unquote, or now quote unquote landlocked property, they maintain a private right of way, an easement, over that old road to, a county maintained road. That expires, if you don't use it, if you can't prove that you're using it. So
Oh, wow.
this property, it is now considered officially landlocked because there's no evidence that people that we're buying it from in the last 20, 30 years that they've used it at all, because they've all been out of state owners. So there's two properties that are separating the subject property from a public road. So we have, reached now tentative deals with each of them and have put easements in front of both of them. We're waiting to get them back to get them signed. And once we do that, we'll be able to close on the property and it'll be a great deal. We're getting it at a great deal because it's landlocked, and the way that we're improving the value is to get it legal access. Now you'll really be able to do something with it. So it can be a long and time consuming process, but really, as long as your neighbor is willing to work with you and you're willing to pay a little bit of money, then it's something that you can easily overcome.
Yeah, and that's really cool. I've I've mentioned it a few times on this podcast already, but I feel like when any real estate investor is at their best is when they're solving a problem that other people can't solve. You're using a specific toolkit that you've developed, where you're adding value, right? Um, that's where those are the deals that I feel best at night. I can go to sleep knowing instead of just I found a property and managed to buy it cheap below market and then I just resold it at market. Um, I just feel much more comfortable that when I've been able to improve a property or solve a problem, because I feel like that's where real estate investors really stand out, right? Because we're creatives in general, and we've learned a specific toolkit to deal with these problems. So that's a really cool project, um, and that is
Totally.
interesting. You brought up. Go ahead.
So go ahead.
I was just going to say, well, no, you go and say what you're going to say because I have another topic I'm going to bring your way.
Yeah, I mean, I completely agree that adding value is those are some of the best deals. Those can also be some of the most lucrative deals as well. And you know, when you're always just trying to find the next flip, it can be great money, but it can also be monotonous. So I love having some of these tough issues to go out and solve. And
Hmm.
I find those very interesting, and they really mix things up and just keep it interesting.
Yep, yep, I agree. And then you mentioned adverse possession. And you already did a brief overview on it, but that is such a. We actually bought a property that had advert. I'm trying to remember exactly how it went. Somebody had filed, uh, I guess, a petition. I don't know what it is, but they filed for adverse possession on a property that we had purchased, but they had never gone through the court process of actually finalizing the adverse possession. So that was kind of my rude awakening to what adverse possession was. But it seems like this bizarre statute where you can effectively just go plant a flag on someone else's property, and if they don't notice in a certain time period, you can own it. Is that really what it is?
That's what it is. And the concept underpinning it is that, like I said, as a general rule, the the government wants land to be utilized. And if you are not utilizing your land for such a long time, like a really, really long time, like I said, in Georgia, it's 21 years. If I just went and fenced off somebody's property and they don't kick me off, to say, all right, well, you were utilizing this property in some way. All right. There's a process through which you can go now say it's yours. But, the where it's most often seen is not just somebody fencing off a property because their neighbor will notice, somebody will notice and notify the owner as to what's going on. Where I've seen it is more along the lines of like boundary disputes and where
Mm,
somebody's put a fence, or like when I was still practicing law, there was a case in downtown Savannah where an investor back in the 80s had bought a group of three kind of apartments, downtown apartments, townhomes type of things, and the courtyard that came with his properties was like a diagonally, it was like a triangle, and then the other triangle went with another property. But there was the only access to the courtyard was through our client, the investor's apartments. The access to the other property, it had been walled off, and then over the course of almost 30 years, the investor had allowed his tenants, and your tenant's use counts towards the owner's use. He allowed his tenants to, you know, plant gardens back there. They had, you know, full use of the courtyard. They had parties. They had, a bathtub that they used as a pond for goldfish. all these other things evidence that we collected through pictures and depositions going back years and years and years. And we won that case because we were able to show, like, yeah, he used this entire courtyard over the course of 30 years, and the next door neighbor knew about it because they were next door.
Hmm.
But the thing on that one was, like, nobody, it was like a far previous owner that had walled off the access from the other property to the courtyard. So, everybody just assumed that the entire courtyard went with our client's property, and they all treated it as such. But
Hmm.
you know, that's typically where you see adverse possession more than, somebody goes out to, and fences off 100 acres and says, "This is mine."
It's a new business idea, though. Professional adverse, because it's not that long in Texas. I don't think it's 20 years. I think it's something like six.
Yeah,
And I don't think you actually have to fence it in. I think you just have to demonstrate use of the property. So the guy that filed adverse possession of us had parked cars on it. That was his
yeah,
adverse possession use.
yeah. It you're right. It's state specific. In most states, there are two different categories of adverse possession. There's the type of, open, notorious, exclusive use, um, and you have no color of title. And then there's that, the no color of title. That is typically the longer period. And if you have it under color of title, that means that you have some sort of deed. There's some sort of property record showing that, like, hey, somebody tried to convey some interest in this property to you, and then let's say that deed turns out to be, um, it turns out to be, you know it was fraudulent on the part of the person that sold it to you, but you believed that it was real and you didn't do anything fraudulent to put that into the property records.
Hmm.
Then that's considered under color of title, and your statutory period in Georgia then is 7 years, and in most other states it's going to be far less than the roundabout 20 years that it would take to otherwise adversely possess the property.
That's neat. All right, I got one more for you. And then we're probably going to head to close on this. So, briefly, because not all of our audience is land buyers and sellers, professionals like ourselves. There's a lot of people who are going to be listening to this who are just interested in buying land for the first time or land in general. So could you do a brief overview, as brief as possible, because I know it's a huge topic, of what title is and like how deeds work a little bit in our real estate system and our legal system? And then maybe are there things on title that you would consider a no-go, or if you see this on a chain of title, you're not going to mess with it, or maybe it would be just overly expensive to deal with a problem like that?
Sure. So title, to distill it all down, is just who owns the property and then what is their interest in the property. So in general, there are three levels of deeds. There's the general warranty deed, and that when you get a that's the highest and best. When you get a general warranty deed, the seller is saying, I warrant to you that I own this property, and if anybody comes out of the woodwork and says, "Oh, you know, I own it," I'm going to protect you against them. And that's where title insurance comes in, because then if that title, insurer, if somebody comes out, that title insurance company will come out and pay for an attorney to litigate that suit. Then you have a limited warranty deed, which doesn't warrant protection against the things that happened prior to the seller's ownership, but it says, during the time that I've owned this property, I warrant to you that I haven't done anything to affect my ownership of it. Finally, you have a quitclaim deed, which that says, whatever my interest in the property is, I give it to you. And quitclaim deeds They're most often used to solve a title issue. So, like, let's say there's an errant deed or something wasn't recorded properly or something like that happened 20 years ago and you have to track this person down. You say, like, hey, you sold this property to your cousin 20 years ago, but it wasn't properly recorded. You know, you agree that you sold it. You're not, claiming an interest in it, but to clear things up on title, we just need you to execute a quick claim deed. And it doesn't say that you own it. It says, if I happen to own it, it's yours, right? So
Uh,
the second part of your question, what are some no-goes on title? So
hmm
air properties are typically the toughest title issue that you can deal with. And what happens here is that somebody passed away without a will, and they could have had, let's say they had 5 children. Let's say 5 children, no wife. Under the laws of intestacy, which that's what determines who gets your property after you pass away if you don't have a will. Say their property interest passed to their in equal shares to their 5 children. So now you have 5 people with 20% interest in the property. Now each one of those, has 2 kids. So now you have a ridiculous number of people with an interest in the property, and it's all a small interest. But there's still one person who's paying the property taxes, all that sort of stuff. Those, a lot of the time, will be no goes because you'll have some people who are on board with selling, and then others
hmm
who you either can't get in touch with, or you just, um, or they're unwilling to sell. You can solve those issues, and we have, so long as 100% of the property interest is accounted for. You're able to go back and, find the obituaries and prove, you know, all the descendants. You find the entire family tree. But the critical thing is that you have people who are willing to work with you to sell the property. It's
hmm
a no-go if you have anybody in there who is just absolutely unwilling to sell the property. And there are some nuances there. There are some legal processes, like you could buy an interest in the property and then go through a legal process called an ouster to try to, get the other people taken off of the property. But that entails a litigation process, hiring lawyers. That is really, a it has to be a deal with tremendous upside, and
hmm
you have to be ready to litigate an entire lawsuit. In my mind, I'd rather just go out and find another deal than fight a court battle to try to, get somebody kicked off of a deed.
hmm Yeah, I'm kind of right there with you. Airship is that's something we've kind of made our forte in solving more of the easier side of airship issues, and we've been able to do that very effectively and add value and make deals full cycle in that manner. But there's like I just had Jason Wolbrink on a few days ago, and he closed a deal in Arkansas that required 9 heirs to sign off on. And it was just wild. He said it took so much time to get everybody on board, all the cat wrangling and everything done through title. But I know that was a multi-million-dollar deal, so it made sense, right? But yeah, if you're dealing with something small, it can be a real pain. Like we are in the process of doing we're doing quiet title on a property that's just not very valuable. We will make money on it, good return, but it's just a long process. So we went forward with it fully understanding that this will just take longer to happen. But we already have a buyer in place. So just once it's all finished, ink it, move on to the next one.
Sure.
Um,
Yeah, we had a property that, granted, some of these were corrective deeds, but it was a 249-acre property, and in total, it required 18 deeds to be signed for us to get title insurance. And there were, yeah, that was a pretty crazy one. But luckily, we had, the we had the matriarch of one of the two families that owned the property who was willing to, you know, whip the 7 or 8 people on her side into getting everything signed. But it took a while. It just took a while. Um, and there's other situations where you get into the quiet title process and things just don't go there is real nuance there, so you have to get an attorney that knows what they're
Hmm.
doing. We had a situation where this guy bought property. He bought it with title insurance, and they totally they totally missed a they totally missed, like, I've no idea how they missed this, but there were uh there was an heirship issue probably 50 years before he bought the property, and only
Hmm.
one of the heirs sold it to him. So he sold it on a quick claim deed. So that means that person who was trying to sell the property to us, uh, he really only owned a percentage of the property, even though for years
Ooh.
he thought he owned the whole thing. The problem is that the other heirs from the other heirs from 40 or 50 years ago, they are considered co-tenants to his property, and adverse possession never ripens against co-tenants. So even if we went through a quiet title process on that property, we wouldn't it wouldn't yield anything without having those heirs from 50 years ago sign off on it as well, and they're long gone.
Oh
Can't.
man,
Yeah.
that's
So
miserable.
yeah. So I mean, I do want people to know that when it comes to legal processes relating to real estate investment, there really is nuance there. Find an attorney that really knows his or her stuff as it relates to those processes. One of the best lawyers that we've ever found, uh, he characterizes himself as a bank attorney, and bank attorneys, they deal with foreclosures, real estate matters all the
Yep.
time, and yeah, he's been a great asset to our team as well. He's taught me a ton about some of these legal processes as well. So I just can't reiterate that enough. Find somebody that really, really knows what they're doing. Don't just go with the first attorney that you find. Consult multiple and use your gut to see who's gonna do the best.
Hmm. Awesome. Well, that kind of brings us to the top of the hour. Did you have anything else you wanted to share over since I have you here? Whatever you might like.
No, I think it's been a great podcast. Just follow me on Twitter at landlawyer Brian. Uh, I share deal reviews, my experience, uh, as growing our land investing business, share some insights on legal topics as well, and some other stuff about timber hunting, fishing, and sometimes general shit posting. So would love to have more people join me over there.
Awesome. Well, thank you again for being on. Folks, thanks for listening. Just a reminder, if you're looking to expand your land portfolio, check out the properties at primelandexchange.com. If you're looking for funding for your next land deal, hit up landpartnerfunding.com. And if you want to reach out to me directly, just email me at thelandfixer@gmail.com, and we'll look forward to seeing you on the next one. Peace.